The Director of National Intelligence, or DNI, has released his report on laboratory origins, and, like the earlier report this summer on unexplained aerial phenomena, the new term for unidentified flying objects, the report may not be what many had expected, failing to establish anything definitive, but leaving enough hope for advocates on both sides of the issue, not even completely ruling out the possibility that the pandemic pathogen had been the product of a laboratory, but, at least, according to one litigant in a case on the horizon for a ruling on proceeding further before the United States Supreme Court has argued there may be more plausible considerations to consider than the two sides currently under consideration in what has become an international debate. Deciding whether a matter has in any measure been committed by the Constitution to another branch of government, or whether the action of that branch exceeds whatever authority has been committed, is itself a delicate exercise in constitutional interpretation, and is a responsibility of this court as ultimate interpreter of the Constitution, wrote Chief Justice Warren Burger, quoting from a previous case. But then reaching all the way back to Marbury v. Madison for authority, he stated, therefore reaffirm that it is the province and duty of this court to say what the law is with respect to the claim of privilege presented in this case. Generally, when it comes to the review of a regulatory agency, the approach in court is governed by the decision of the U.S. Supreme Court in Chevron USA v. NRDC. The 1984 case that cemented the doctrine of regulatory deference, stating, "We have long recognized that considerable weight should be accorded to an executive department's construction of a statutory scheme it is entrusted to administer, footnote omitted, and the principle of deference to administrative interpretations has been consistently followed by this court whenever decision as to the meaning or reach of a statute has involved reconciling conflicting policies, and a full understanding of the force of the statutory policy in the given situation has depended upon more than ordinary knowledge respecting the matters subjected to agency regulations and, if this choice represents a reasonable accommodation of conflicting policies that were committed to the agency's care by the statute, we should not disturb it unless it appears from the statute or its legislative history that the accommodation is not one that Congress would have sanctioned. But, in the current public health crisis, many have argued that the circumstances are controlled by the 1905 case of Jacobson v. Massachusetts, an opinion penned by Justice Harlan, in which he stated, then, vaccination, as a means of protecting a community against smallpox, finds strong support in the experience of this and other countries. No court, much less a jury, is justified in disregarding the action of the legislature simply because, in its or their opinion, that particular method was perhaps or possibly not the best either for children or adults, but also took deliberate time to provide a proviso and caveat for this endorsement of the police powers of the state, and, in that opinion that had begun with a firm chastisement of the appellant to remind him that no power can be exerted to that end by the United States unless, apart from the preamble, it be found in some express delegation of power or in some power to be properly implied therefrom, the Supreme Court emphasized that where a regulation purporting to have been enacted to protect the public health, the public morals, or the public safety has no real or substantial relation to those objects, or is, beyond all question, a plain, palpable invasion of rights secured by the fundamental law, and it is the duty of the courts to so adjudge, and thereby give effect to the Constitution. And these precedents present the setting for a developing controversy before the United States Supreme Court, in a challenge brought against the facial coverings mandates in the Commonwealth of Virginia in the U.S. District Court for the Eastern District of Virginia on the 2nd of June, 2020, the first filed, and longest surviving challenge brought against the facial coverings mandates in the entire state. But, on appeal, the focus of any controversy shifts to assignments of error by the trial courts and any intermediary appellate courts. So, in this case, while facial coverings mandates provide the background facts for the argument, the issue for decision is whether, when the U.S. District Court had dismissed the case on the 25th of August, 2020, it was a proper action by the court or done in error. And, at least Major Mike Webb, who is not only the appellant bringing the petition for certiorari, but also the advocate for his own matter, the case was improperly dismissed, and it is of note that, to date, Mark Herring, the state attorney general who had boasted of at least 15 easy victories in courts defending Virginia Governor Ralph Northam's COVID-19 response, has yet to make an appearance in the case that has made its way from the U.S. District Court in Richmond to an appeal before the Fourth Circuit, and now is being considered by the highest court in the land. Webb presents several unique challenges against the facial coverings mandates that have not been tried by any attorney in the nation during the legal challenges brought against the COVID-19 response, but Webb has a very unique background, holding the distinction of having been the most junior commissioned officer to have ever served both as the aide-de-camp to the commander and as the operations officer for all U.S. Army strategic counterintelligence in the continental United States, and that practically makes him qualified to be certified as an expert under the federal rules of evidence on an issue that was most recently the topic of a complete report from the intelligence community that had been requested by the president in May, the issue of laboratory origins of a novel coronavirus. And, while that long-awaited report, which was released just last week, has many doubtful that a determination can be made beyond a reasonable doubt as to whether the pandemic pathogen had been the product of a zoonotic evolution, as argued by the nation's leading infectious disease control expert, Dr. Anthony Fauci, or if, as former MI6 director Sir Richard Dearlove has argued since last summer, the virus had escaped from the laboratory in China does not appear to be a vexing conundrum of complexities to Webb, who argues that there is no need to gain complete access to the laboratory in Wuhan, because the science, he says, is already there in open view and published in the open source in multiple science reports that have been posted on the internet, not just during the current public health crisis, but dating decades before. This matter presently before the Supreme Court will probably not determine why the nation's only physician serving as a state governor decided to exercise a right to remain silent and attempt to avoid this case, raising potential allegations of evasion of a summons from the United States Marshal, a felony offense that is punishable by up to 20 years in prison, as well as a predicate offense under the federal racketeering statute. This matter before the Supreme Court will probably not decide whether the facial coverings that had been definitively determined to be wholly ineffective in a respiratory tract infection public health crisis during the Obama administration a decade ago, and which no credible study since has established might be effective at preventing microbial infection. But it is intriguing that Rochelle Walensky, the CDC director, Dr. Fauci and even Governor Northam have never made any specific reference to any study to support their scientific conclusion on the effectiveness of the non-medical grade facial coverings, but rather have used what would, in any other instance, be described as a logical fallacy argument relying on false authority, like saying "trust me because I am a doctor." And, for the intelligence community, this matter before the Supreme Court will probably not decide why the President has refused to respond to a Freedom of Information Act request to determine whether the infectious dose and the secondary attack rate for COVID-19 is classified information that remains unknown, despite being routine metrics for epidemiologists for assessing risk, and quite easy to determine. But, as the Supreme Court had stated in USA v. Nixon, absent a claim of need to protect military, diplomatic, or sensitive national security secrets, we find it difficult to accept the argument that even the very important interest in confidentiality of presidential communications is significantly diminished by production of such material for in-camera inspection with all the protection that a district court will be obliged to provide. And, since the 20th of March, no such statement has been made regarding national security secrets connected to the infectiousness of COVID-19, and, under Executive Order 12,958, classified national security information, dated the 17th of April, 1995. This information could only be classified if 2019 GOV, the purported causative agent for the disease COVID-19 was, in fact, the property of the United States. However, in a separate action, filed on the 7th of July at the U.S. District Court in Richmond and naming Dr. Fauci as the lead defendant, Webb has petitioned for the issue of a writ of mandamus that would compel the White House to answer that question, and he hopes to obtain more information regarding how much Dr. Fauci knew about a SARS-like coronavirus about which he had informed his deputy in February 2020 that had been cultivated in vivo and in vitro at the University of North Carolina, Chapel Hill, working in conjunction with the Wuhan Virology Institute in 2015, which has all appearances of a classified special access program that had been engaged in dual-use research of concern, or, to say it plainly, a biological weapons program. Reporting from the United States Supreme Court, good night, farewell and good evening. This report has been unclassified.
This advertisement was authorized by Mike Webb.